afternoon, everyone. My name is Pat Wilds. I'm the director of the Government Law Center here at Albany Law School. The Government Law Center has been around for nearly 50 years now. Our 50th year anniversary will be in 2028. We analyze, we educate, and we drive conversations on pressing issues facing state and local governments and prepare the next generation of government lawyers and leaders. On behalf of the GLC and the law school generally, thank you for joining us for the fourth and final program in this year's Warren Anderson Legislative Series. Taking place annually between February and May, the Anderson Series programs focus on major legal and policy issues facing New York State government. The series is named in honor of Warren Anderson, Albany Law class of 1940, who served in the New York State Senate for 36 years, working with 6 different governors. He was the longest serving majority leader of the Senate, holding that position from 1973 to 1988. And the goal of these programs is ultimately to explain and promote dialogue about current and propose law and policy rather than to advocate for a particular policy or course of action. I also want to take a moment to acknowledge and say thank you, a big thank you to our generous sponsor of this year's entire program, 4 programs, a contribution made in the memory of Sharon P. O'Connor, the Albany Law School class of 1979. And thank you to our program sponsors for today's event, the Civil Service Employees Association, also known as CSEA, and Lips Mathias LLP. Without further ado, I'll hand the program off to our moderator today, a colleague of ours here at the law school, Professor Lauren DesRosiers, who is the director of the Immigration Law Clinic at the Edward P. Swyer Justice Center here at Albany Law School. So Lauren, I'll hand it off to you.
Thanks, Pat. Hi, everyone. As Pat mentioned, I am the director of the Immigration Law Clinic, and I'm joined today by 3 really terrific guest speakers who I'm going to introduce right now. So first we have Cianna Freeman-Tolbert, who is a partner at Whiteman, Osterman, and Hanna. And next we have Zach Ahmad, who is the Senior Policy Counsel at the New York Civil Liberties Union. And we are going to wrap that up with Yasmine Farhang, who is the Director of Advocacy at the Immigrant Defense Project. So I'm really excited to have a conversation with the 3 of these folks today. And we're going to kick it off and get started right away to try to get as much of this conversation out of this conversation as possible. So I want to start by kind of giving an overview and understanding the broader picture of what immigration in a federal context, in a local context, and in a state context ends up looking like, because although it's a federally regulated area of law, it still has effects at the local and community level. So to start us off, I'm going to ask if Zach can answer a couple questions that I have. So Zach, can you talk a bit about how state and local governments are or are not permitted to work within immigration enforcement and within the larger immigration regulatory structure?
Sure, and thank you for the question. Thank you all for being here. It's a big question, so I'm gonna do my best to be concise. So as Lauren mentioned, and as probably everyone on this call is aware, immigration enforcement is primarily the prerogative of the federal government. It's the federal government that sets immigration policy and is responsible for enforcing immigration law. But as you also mentioned, states and localities do often lend a hand to federal agencies like ICE, Immigration Customs Enforcement, and CBP in ways that are both formal and informal. So, one very common way this happens on the enforcement side is through a program known as Secure Communities and the detainer requests that it enables. So trying to unpack that a little bit. So under Secure Communities, when a person is arrested for a fingerprintable offense, their fingerprints are shared with the state, which shares them with the FBI, which through a system that they refer to as interoperability, automatically makes them available to ICE. So ICE is notified of a person who has been arrested in a local jurisdiction. ICE will then send a detainer request to the local jail or police department, which is essentially a request asking them to do one of 2 things, to either hold that person for up to 48 hours beyond their release date so that ICE can come pick them up, or to simply let ICE know when that person is being released so that they can come and do the same thing. This is something that happens all the time, and that makes up a large share of the arrests that ICE makes. There are some jurisdictions that have laws in place or policies in place of not responding to these detainers. I know we'll get into that, throughout the program, but that is one way in which that kind of cooperation happens. In addition to that, local law enforcement frequently enter into agreements or contracts of different kinds to play a role in immigration enforcement and detention. One way this is done is through the 287G program, which I think we'll probably talk about a little later in more detail, where local law enforcement agreed to deputize some of their officers to enforce immigration law. Separate from that, what are called intergovernmental service agreements, or sometimes referred to as IGSAs, contracts whereby local jails rent out their cell space to hold people who are already in ICE detention in those local jails. However it is that they got there. So it's more cooperation on the detention side than the enforcement side. This happens across the country, and it happens in a number of jails in New York, most notably in Orange County in the Hudson Valley, in their jail near Goshen. And then beyond these formal agreements, there are all sorts of informal and ad hoc ways in which government agencies and their employees, primarily law enforcement, but certainly not always, work with ICE and CBP and Border Patrol. Individual officers might have personal relationships with ICE officers and share information back and forth. There are a lot of anecdotal reports of police in border regions, often using CBP officers as interpreters in sort of routine local law enforcement interactions. And there are any number of ways that, police or other government entities that collect information from people can share a person's personal information with ICE upon request. So, to the second part of the question, in terms of, the voluntariness of this, just about everything I mentioned, want to stress is voluntary. Local law enforcement do not have to respond to detainer requests. That's why they're called requests. They do not have to enter into 287G agreements or IGSIAs. They do not have to share information, and state laws or local laws can prohibit certain participation. I think we'll get into that a little bit later. Just one example, in New York, a state court has held that under our criminal procedure law as it exists now, local officers have no authority to make civil immigration arrests, which consequently means that they don't have the authority to hold a person beyond their release date for civil immigration purposes in response to a detainer request. States and localities that cooperate with immigration enforcement are not required to do so. They are making a choice to do so. They have a choice as to how they use their resources, and those that cooperate are making a choice that they want to use that in that way. I'll pause there.
Sorry. I have a couple follow-up questions on that. So just to clarify, you said a detainer request. Is there any obligation for local law enforcement agencies, so like local PD, local police, to affirmatively reach out to ICE or any other federal agency to see if there's a detainer?
No, and that's not typically how it happens, and there's certainly no obligation for them to do so. Typically, the way that ICE learns of an arrest is through secure communities, and then the detainer is sent on their end to the local law enforcement agency. Yeah.
And Yasmine, you might also have some input on this, but what is a fingerprintable offense? You mentioned under secure communities, if somebody is arrested for a fingerprintable offense, that information gets automatically shared with certain government agencies. What type of offenses are those?
I think there is part of the challenge in answering this is that it's not static, right? And it can be quite ever changing. And this is coming up in particular right now in New York City with some evolving kind of law enforcement practices on the ground. So, even when at different times we're able to say, here are categories of offenses that are more likely to lead to fingerprints and those that are not, we are seeing changes. For example, right now we're getting a lot of questions about some of the changes in policing around bicycles and biking, for example, in New York City, and questions about, what people traditionally were able to expect as being something where they would get, a violation or a ticket, now being a question of whether they might be fingerprinted and have to go to summons court, So I'm wary of giving any definitive answer because of the fact that not only is this ever changing in New York, but we see so much inconsistency in this around the country. We know that anything where we're seeing increased policing increases the chances of fingerprinting and therefore increases the chances of information sharing that can lead to detention and deportation.
So that sounds like quite a bit of information sharing, just as a kind of like static baseline already. Cianna, I saw your hand.
Yeah, I was just going to say, in practice, what I've seen, because I used to live down in Atlanta, and where we were, they had a 287G agreement, is it was no license. So when you were driving and you got pulled over and you didn't have a license, that was something that you would get pulled out for and get fingerprinted for. And we had a lot of people being detained due to having no license. That's why the green light law here in New York is so important, because driving without a license is one of the things that can get you pulled out of your vehicle and taken down to the center and fingerprinted.
Thank you. I think we might have a chance to talk a bit more about green light and what it looks like right now and why it's important. But before we kind of jump into those details, I just want to make sure that we are fleshing out the kind of broader structure. So we have the secure communities and the detainers, we have the IGAs, and we have the 287Gs. So those are kind of three ways that information sharing is already happening kind of as a default within state and local agencies and the federal government. Am I understanding that correctly? Zach, I'm going to ask
Yeah,
for you to
those
give
are,
that.
I think, three major pillars of how this happens. And as I mentioned, there are all sorts of informal and other ways in which, information is shared. I'm hitting on some of the key points.
I don't want to go too far into the nitty-gritty of the 287G agreements, but what do those end up what distinguishes 287G agreements from the other two ways of information sharing?
Sure. As I mentioned before, the 287G program is sort of the most formal way that this kind of collusion and collaboration between local law enforcement and immigration authorities happens. So 287G is a program that was established under the Immigration and Nationality Act, the INA, that allows ICE to enter into contracts with local law enforcement, train them, often minimally, but train them to enforce immigration law, and then formally deputize them to engage in immigration enforcement. So there are currently three different models of the 287G program. There's the jail enforcement model, whereby corrections officers in local jails are charged with interrogating people in their jails about their immigration status, and processing people for immigration arrests when they believe they have grounds to do so. This sort of all takes place in the jail under the supervision of ICE. And then similar to that is the warrant service officer model. This is sometimes referred to as 287G Light. This also sort of exists within the jail context, and it authorizes corrections officers within jails to execute ICE administrative warrants. Again, oftentimes this collaboration happens even just without a 287G agreement, just by responding to detainer requests and maintaining that kind of open line of communication. But this is a program that sort of formalizes that and puts in place a contractual structure between the agencies. And then there is a third model of 287G that's known as the task force model. This is sort of the most I don't know what the word I'm looking for is, the most severe or direct model. This model operates by deputizing officers in the field to perform immigration enforcement in the course of their day-to-day operations. So you're taking this sort of outside the context of the jail and corrections officers, and you're deputizing officers in the field. This is a model that was phased out more than a decade ago during the Obama administration, following a string of documented civil rights abuses associated with the program, most notoriously by Sheriff Arpaio in Arizona, which might ring a bell for people. And then it was not revived under the first Trump administration or under the Biden presidency. It was only brought back in January of this year, pursuant or at least following an executive order ordering DHS to consider all potential models of 287G. And so just to kind of bring this back to New York, in New York, there had actually never been any 287G agreements prior to 2018. That's when Rensselaer County became the first to enter into one. They had a jail enforcement model. And that remained the only agency with an agreement up until this year. There are now 6 agreements in New York State in 4 different counties. There's one in Rensselaer, there's one in Broome County, and then there are 2 each in Nassau and Niagara counties. And the last 2 that I mentioned have task force agreements. So it will be interesting to see how that plays out. So it's a rapidly growing program. There are indications that it is sort of a central piece of this current Trump administration's mass deportation agenda. It is something that we're seeing grow across the country and also here in New York.
Thank you. So Cianna and Yasmine, if you can chime in, I'm interested in hearing a bit about how you're seeing this play out in communities across New York State, particularly right now, just given that so many things are currently in flux and in some ways very untested.
Sure, I'm happy to get us started. So I think when we are trying to really understand how the entanglement, right, of local and state agencies with ICE and federal immigration enforcement impacts people and their communities, we're sort of talking about 2 things that are obviously very much related, right? One is we're talking about how sort of examples of sort of systematic ways in which this collusion happens routinely in ways that put New Yorkers at risk, right? But then we're also talking about examples where individual employees of some local or state agency are affirmatively choosing without anything prohibiting them otherwise, or even where something prohibits them otherwise, to affirmatively take action that colludes with federal immigration enforcement, right? So just to give some really concrete examples of what we're talking about in both of those ways, we here in New York City, and we'll talk about this more later, but, we have legislated around this, right? Over a decade ago. And since we have passed a number of local laws that we'll talk more about that really, create some significant prohibitions around the way that our local agencies share information with ICE and work with ICE to facilitate people being transferred to their custody. And yet we have seen through community members' own experiences and testimonies, and also through information we've been able to obtain through freedom of information law requests and otherwise, that there have been some patterns of agencies going above and beyond even what they are prohibited from doing, what they are allowed to do rather, and where there are systems that are creating a really tight collusion with federal immigration enforcement. So specifically, the New York City Department of Corrections, in the last 6 years almost in particular, we have tracked routine ways in which the Department of Corrections communicates very closely with ICE in order to, in certain circumstances, slow down the release of people in order to ensure that they're released in a way that is timed for ICE to take custody of them and to transfer them to ICE detention and initiate removal proceedings, right? And just to give you a little bit of an example, of what this means really practically. Before some of our local laws, so looking back about a decade ago in New York City, what this meant was that somewhere between 3,000 and 4,000 New Yorkers a year were being transferred to ICE custody because of the Department of Corrections, because of a city agency's involvement in that federal immigration enforcement. So that's kind of a little bit of a systematic example. But today we have many individual examples that continue to show us what happens in both sort of conflict with existing protections we have at the state level, and that where individual employees have violated existing laws. So a really concrete recent example that many people may have seen is that there was a New York inspector, so this is an employee of a state agency that does sort of inspections of truck drivers and others to ensure that they're complying with various rules and regulations, stopped 2 truck drivers. They were pulled off the side of the road in order to, make sure that they were kind of complying with routine regulations for truck drivers. And in that process, the state employee, based solely on the fact that the person was limited English proficient, and presumably based on what they looked like, chose affirmatively to make a phone call to CBP, which resulted in the person being handed over to ICE and deported. Right. And so that was an example that, of an individual employee making the affirmative decision, right, to share that person's information. And another example that I think is important to illustrate at the city level, because in this case, it actually goes against some of our city laws, is a case a couple of years ago that we have previously shared of a mother in city shelter who reached out to shelter staff asking for some support services for herself and her children, only to have her information shared with ACS, and then to have the ACS caseworker share her information with ICE, which resulted in her detention by ICE and her separation from her children. So those are some just really concrete examples of sort of both systematic and individual ways that, in which collusion is resulting in New Yorkers being harmed and being detained and deported. But I think it's also really important when we think about the impact of collusion to also understand the impact to people who are not being directly impacted, right? Who might not have had their information or their loved ones' information shared with ICE, but who are non-citizens and who are seeing this unfold around our state. And so one of the really significant impacts for all New Yorkers, and I think it's safe to say not only to non-citizen New Yorkers, considering the element of racial profiling happening in so many of these cases, right? That is happening regardless of immigration status, and even for US citizens, is that it creates a significant chilling effect, right? So for people who want to participate fully in their communities, who want to access their local agencies and critical services, whether that's for health or education, right? For housing, or if it's to report wage violations or labor exploitation, right? When people are seeing in their communities that local and state agencies are sharing information, transferring people to custody, they can no longer have meaningful trust in their local and state governments. And that creates a chilling effect that impacts many people, right, in New York. And I would say both non-citizens and citizens.
And I would just say, just to kind of bring it full circle to the perspective of the foreign national, right? What does this cooperation do for them? What we're seeing on the ground, a lot of things that are happening is when someone is detained, and because the jail may be trying to wait for the detainer to come or wait for ICE to come and pick them up, they will release them to ICE before their criminal case is adjudicated. What does that mean? That means that our clients, our foreign nationals, are going into immigration court. We're trying to get them a bond. We want to prove that they're not a danger to society. And all we have is an arrest. We don't have a conviction. Nothing's ever happened but this arrest. And so they don't really have the opportunity to defend themselves in court. So it's that part of it that's really upsetting for a lot of our foreign nationals who get arrested. They have a police report that's written about why they were arrested, what was the probable cause, and then they are moved to ICE before there's a final adjudication. And when that happens, you don't have the opportunity to have due process in the criminal courts. And so when we go to immigration court, and now we're trying to argue that this person is credible and that they have good moral character, whichever application we're putting in front, we have this police report that hasn't been adjudicated that the immigration judge is looking at. And so we're in the position where we're arguing that there is no final adjudication. This is their position on this, and it makes it an uphill battle. So those individuals, more likely than not in this administration, end up being detained when maybe if they would have finished their adjudication in criminal court, they would have been found not guilty or would have been dismissed or something, or been another lower charge. But now I have a foreign national that's in immigration court being detained throughout their whole immigration proceedings because they were moved too quickly. And that's what we're seeing a lot of.
Is it common practice or how frequently, if somebody is moved to ICE custody on a detainer, how frequently does ICE assist with bringing somebody back to be, I guess, be prosecuted for the criminal offenses that they were arrested for?
First of all, there's a first assumption that the individual has the public defender, at least has a public defender that's communicating with your immigration attorney, and that you guys can coordinate where he is, right? Because most public defenders, they've been released to ICE custody. They're in up here in upstate New York, it's Batavia, and they are more likely than not going to be returned to criminal court to adjudicate. And I am referring to all levels of crimes. DUIs, that's the most common that we see happening. They'll get arrested for a DUI and then they're going to be moved to ICE custody. That DUI is never adjudicated, but they're not going to be released on bond from immigration court because they have a DUI pending. And the judge can use that when determining whether or not they're a danger to society. And so it's just this cycle. And no, there's not much incentive at all for ICE to assist in helping them go back to court to facilitate that. Sometimes you get a good judge in state court who might let them plea in absentia or something like that. That's the best we usually get.
The only thing I would add is that the DAs do have the ability to file a writ for ICE to return the person to appear. An ability, right? And previously, but before this kind of the trends that we're seeing under this administration, there were cases, right, where the DA would file a writ for someone to be produced to appear in their case to continue their criminal proceeding. But as much as there were already, to Cianna's point, a lot of limits and kind of challenges to that in the past, now that is even bigger because of the speed and the frequency with which we are seeing people transferred. It used to be that if someone were detained, for example, in New York City, we might reasonably anticipate where they were going to be and how long they were going to be there. And now what we're seeing is that loved ones and attorneys are having a really hard time in the aftermath of ICE detaining someone, tracking where they are. They might be moved from New Jersey to Pennsylvania to Texas and then to Louisiana within a matter of days. And also that even the most basic of systems that people can use, like the ICE locator to identify where someone is, are not being updated in real time, considering all of that. And so the very real experience that many people have of someone being disappeared is quite literally in part because often you don't know where they are, right? And so that just practical reality, it makes it even further challenging to imagine, as has already been said, the very few circumstances where someone is actually going to ever be returned to appear in their case.
I mean, in practice, we always encourage individuals to stay in the local court as long as possible. So if the criminal attorney can put the hearing further, we can do anything so they're not transferred, because once they transfer them to ICE custody, we know we're on the chase and we're going to be seeing where they're going to end up, and we don't know where it will be.
One of the recommendations that I heard from an AILA webinar maybe back in April was for people to put air tags in their clothing and give that access to somebody that they trust. I think that opens up an entirely different door to the expanding world of digital surveillance and the concerns that that raises. But I think that it illustrates the extremity to which people literally cannot be found within these systems. And that has been a longstanding practice and a longstanding issue. Are there any, there's been some legislation at the federal level over the past few months that have exacerbated some of these issues. I am happy to have, I think all of you are qualified to talk about this. So whoever wants to jump in and talk maybe a bit about the Laken-Riley Act and how that has changed some of these calculations.
Sure, I'm happy to get us started. So I think, as many people saw very early on in this federal administration, the president signed the Laken-Riley Act, right? Which, to be clear, was a bill that received bipartisan support, and one that exploits a really tragic murder to criminalize immigrant populations in one of the most expansive ways we have seen through legislation in a very long time, right? Vastly expanding immigration detention, and also just undermining some of the most basic kind of expectations of due process, even the those that we are able to continue to articulate. So some of the key things to know, and this is actually really connected to what Cianna was just saying in the previous question, is that certain people who are facing charges, right, who have their cases pending, who've not been able to resolve them, right, in certain circumstances, one being shoplifting, right, will be detained by ICE, have the ability to be detained by ICE without any opportunity to ask for release at all in an immigration court, right, while their case is pending. And someone doesn't have to be convicted to be forced into mandatory detention under the act, right? Even an arrest kind of based on an accusation is enough to detain someone under the Laken-Riley Act kind of indefinitely until their immigration case is over. And then it also gives really broad ability to sort of sue the federal government over immigration decisions that some states don't like. For example, states can go to court to sort of force agencies to continue detaining someone or deport someone. And, already, as a result of laws that were passed in 1996, right, which really sort of supercharged the mandatory detention and deportation. This really takes us a huge step further in terms of really casting a very wide net of people who are going to face prolonged mandatory detention and deportation without due process. And so this will really it is primarily impacting, many immigrants, of whether very long time immigrants who've been in the United States for decades, or recent arrivals, right? Who are undocumented, if they have been, arrested, charged with, convicted of, or admitted, right, under any circumstances, admitted that they committed a list of crimes, right? So those include burglary, theft, shoplifting, and a number of others under the act. So, I think the impact is that some people are going to be forced to remain in detention based on accusations. And it's also very likely, and we're already starting to see this, will have a direct impact on the increase in racial profiling and other types of profiling of people. And also has a direct impact on the budget that ICE is continuing to seek in order to fund them to carry out the goals of the Laken-Riley Act, right? So ICE is now able to say, this law was passed, but we can't carry it out because we need a bigger budget and more manpower to carry this out. And so it now further fuels their attempts to get more funding and more capacity to carry out the federal immigration agenda of this administration.
And I would just add one small piece, because I think the piece that really about this act that really caused the big deal was the shoplifting. Shoplifting became one of the crimes in the Lincoln Raleigh Act that you could be arrested for. And shoplifting is something that, yes, it's wrong. But it's something that sometimes people just, release on a ticket, or like it can be something small. And sometimes people are in a situation where they're shoplifting for food or what have you. And so it was upsetting to see as someone that practices removal proceedings, because shoplifting is usually not something we consider a major crime.
I think speaking to the racial profiling aspect, I know I personally have walked out of a shop accidentally with carrying something that I hadn't paid for. And of course I ran back and paid for it. And it wasn't a problem because I am perceived in a certain way. But I think if there were if I had other identities, it would have ended up in a very different context.
That's such a good point, because you have to remember these individuals are coming from different cultures. They speak different languages. Sometimes they don't understand the way our shopping stores are laid out or what have you. I've heard all types of stories. So that's just a really good point about you making a mistake, and it can be so long lasting and put you into mandatory detention.
We keep talking about detention. Would somebody be able to explain what detention is? Is that a easy, pleasant experience or place to be?
Oh, you can go ahead, Yasmine. So I always tell individuals that initially when someone's detained, and say someone has never been in trouble before, if they're in a local area such as the Albany area, they're gonna be detained in a local jail, right? And that's very scary for them initially, because they're amongst individuals that has committed misdemeanors and crimes, U.S. citizens, what have you. They're there, and that's very intense. When you go to detention facilities, which are, immigration detention facilities, typically also very intimidating, but at least it's a better situation where they're separating individuals usually they separate them based on what they're there for. So if someone's there for an aggravated felony, they have a different color, and sometimes they're in a different area sometimes. But it's not as intense as being in these local jails. That's why it's more concerning when you're using local jails to house these individuals, because some of them haven't broke any sort of have any violent crimes in their past, and they're being housed with individuals who are violent criminals. And I have had lots of interactions with people in these jails who just want to leave. It causes people to want to self-deport and just say, end it. They don't want to fight their cases because they're in a situation where they've never been before. For the most part, I will tell you that the other individuals, inmates, are not kind to them in these jails. So we have a lot of harassment going on. And so it's a terrible situation. I know we just talked earlier about having your client stay and have it adjudicated in criminal court so they have a final conviction. But on the other hand, you kind of want to get them out of that local jail sometimes, especially when they don't have any history, because you want to get them to a detention facility where they're amongst other foreign nationals. Sometimes there'll be other people that speak their language and it'll be a little more comfortable for them. Just my perspective.
And
Yeah,
just
one
one
thing.
thing,
Sorry, go ahead, Zach. Oh, go ahead.
No, just one quick thing to add on to that. Cianna talked about kind of the local jails and the federally run immigration facilities. There are also a lot of private prison companies that have a major stake in immigration detention and run several of the larger and more prominent immigration detention facilities around the country. And as Cianna was saying, these are jail-like facilities, regardless of who you're being detained near or with, or the other types of people that are around you. It is still detention. It is still a prison-like environment run, and these private detention facilities are run by the same companies that run private jails and prisons that house people who have been convicted of crimes. There are, reports of horrendous conditions at these facilities, particularly under this Trump administration. A lot of reports of overcrowding to the point of, causing people severe medical and mental health distress. So, regardless of where you are being detained, it is still detention. It is still a confinement of your freedom, and it is very, very, very often a jail or prison-like environment that you're being detained in. Sorry, go ahead, Yasmine.
Yeah, I just wanted to add, for those who aren't familiar, just what kind of scope we're talking about. The US has the largest immigration detention system in the world. So just to kind of put it into a little bit of context, when we're talking about how many people are detained in immigration detention, just to give a little bit of a sense, I don't have the latest number, but I think it was in 2023, the US detained over 273,000 people across, like, to the points of both Cianna and Zach, like detention centers, jails, private prisons, right, all together in all different circumstances. And I think one thing that I would really urge us to keep in mind is that, many people are rightfully shocked about the way that ICE detention centers treat people, right? And the experience people have, and to Cianna's point, that it's very coercive, right? It's very intentionally coercive, because for many people, the idea of continuing to appeal a case, for example, if they want to appeal it up to the circuit, for example, and continuing to face prolonged detention is going to really impact sort of their decision making around whether they're going to keep fighting their case. But I really want to caution us when we think about what is so shocking, right? Which is the conditions, which are horrific in many of these places, the separation from families and loved ones, the subject to severe medical neglect and abuse. Let's be clear that the same things that are appalling here are the same things that are appalling in all conditions of incarceration in this country, right? Regardless of whether we're talking about civil immigration detention or the criminal legal system. And I think that that is a really important lens for us to see this, and that when we're shocked by what we see in ICE detention, we should be equally shocked by the conditions that we see by people who are incarcerated who are US citizens or non-US citizens.
I have a great transition to our next topic, but I want to make sure that the CLE code is announced.
Yes.
Michelle, do you want to take that?
Yes. For those of you who are attorneys, your CLE code for this program that you have to write on your affidavit is visa. We'll be talking a little bit, I think, about visas shortly. That's spelled VISA. You should be seeing it on your screen. Again, attorneys looking for CLE credit, that is visa.
Thank you, Shell. I think we'll get to, hopefully we'll get to these as we have so much to cover. I feel like we need another couple hours to get through all of this. But I want to talk just very briefly about how I think that this gives us an example to talk about how state and local laws can actually have a really big effect on how things play out in an incarceration or detention setting. So Zach, you had mentioned that there are for-profit companies that make a lot of money and that have had their stock prices increase dramatically over the past few months at the news of immigration detention expansion. Are those present in New York?
No, fortunately, there are no private prison companies operating detention facilities in New York. There is a federal detention facility at Batavia that is operated using private contractors, as I believe is the case with all federally run immigration detention facilities. But there is not a Geo Group or Core Civic owned facility in the state of New York.
And do you know why that is? This is a pop quiz, apparently. Sorry.
What's that?
Would you be able to talk about why we don't have any private prisons in New York?
I'm not sure I have an answer for why we do. So there is, I'll just say at the state level, we have laws in place that prohibit our state Department of Corrections and Supervision from using private prisons for our state and local criminal detention apparatus. That does not reach federal facilities. I think we might be getting to, some of the legislation that's pending a little later. There is legislation that would expressly prohibit private immigration detention facilities in New York, but that legislation has not become law. I don't have an answer for the reason for why we currently do not have any private detention facilities, but at the moment there's one federal immigration detention facility in Batavia near Buffalo, and there are several local jails that have contracts, as I was mentioning earlier, to rent out their cell space.
I think we are eventually going to have to end this program. So do you want to talk a bit about the current pending legislation that would address this issue?
Sure, yeah, and I can talk about some other pending legislation as well. We talked earlier about how, states cannot set immigration law. That's for the federal government to do. But they can enact laws and policies that impact, the lives of immigrants living within their states. Generally speaking, I think there are two buckets those laws fall into. There is sort of laws that, control how the state spends its own resources and sets limits on how they cooperate or interact with immigration enforcement. And then there are other laws that extend certain benefits or privileges that the state offers to people regardless of their immigration status. We have some of those laws in place right now. Several years ago, we passed the Protect Our Courts Act, which sort of circumscribes ICE arrests happening in state courthouses. And then we've also extended benefits through the green light law that makes expanded access to driver's licenses regardless of immigration status, with some accompanying privacy protections. And then there's also been funding allocated for the purpose of immigration legal services. But the fact is that New York is actually quite behind some of our peer states like California or Illinois, or other states I could mention, in terms of passing some of these laws that impact the lives of immigrants. So there are four bills that I think are most kind of prominently on deck in our legislature right now that would impact the lives of immigrants. I'll start with the one that you mentioned, which is the Dignity Not Detention Act. This is a bill that would ban those detention contracts that I and Cianna were talking about that local jails enter into to rent out their cell space, and additionally would prohibit private detention facilities from opening up in New York. Fortunately, we don't have any now, but this law would sort of make sure that's the case into the future. There is also the New York for All Act. That is a bill that goes hand in hand with Dignity Not Detention and sets limits on how state and local law enforcement and other government agencies can use their resources for immigration enforcement, including by, for example, prohibiting them from responding to detainers without a judicial warrant, or entering into 287G agreements, like the 6 that we have already, and it would cancel the agreements that we have now. There are also some other bills. There's the Access to Representation Act. I mentioned that we provide funding for immigration legal services in the state, not enough of it, but we do some of it. This bill would essentially create a guarantee of state-funded counsel for people in New York, or who have a certain nexus to New York, who are in removal proceedings. And then there's also a bill known as the Clemency Justice Act. This is a bill that aims to make the clemency application process, the criminal clemency application process, more accessible and transparent in the state. And specifically, it allows people who have an urgent need to get a decision on a clemency application, such as a pending removal case or a removal order, to get an expedited decision on their clemency application. So that can potentially help them in their efforts to fight deportation. So yeah, there are things that New York State can do sort of, to impact the lives of immigrants living here. And those are just 4 examples of things that are kind of pending before the legislature right now. And we'll see how that plays out over the next few weeks. Our legislative session wraps up in mid-June.
I don't know if you want to add anything, Yasmine or Cianna.
I can add on the city level, Lauren, if that feels like the right moment for it. Just quickly in terms of obviously New York City is in a slightly different place in terms of our existing protections, but we have a lot of, but there do continue to be legislative efforts that I'll touch on briefly. So just to give a little bit of history, we often hear kind of people refer to our sanctuary laws in New York City, and just to be clear on what we're talking about when we say that, over, the past dozen years or so, we've seen local laws kind of build on a much older executive order, from the 80s that kind of barred city officials from sharing information about immigrants in most circumstances. And so in the past dozen years, first, in 2011, our city council passed a law to limit when Department of Corrections would hold people for extra time after the point that they would have been released for ICE. And then later that was expanded to increase protections for people interacting with both NYPD and DOC, which was also the 2014 law that barred ICE from operating on Rikers Island, where they used to have a trailer that was housed there and gave them sort of unfettered access to non-citizens. And then in 2017, the city council passed laws prohibiting the use of the use of city resources and personnel time for federal immigration enforcement, and requiring some reporting kind of requirements and mechanisms for those instances to be shared. There are certainly exceptions in all of these that I won't get into now, but these were hugely sort of groundbreaking pieces of legislation that really changed the landscape in New York City around what the relationship between local city agencies and ICE enforcement looks like. There are a couple of things to note now in terms of what sort of legislation is under consideration. I made reference before to instances where our existing laws are violated. So there's a current law called a current bill called the New York City Trust Act. It's Intro 214, which is pending in the city council, which would create a private right of action so that any individual New Yorker who has experienced harm as a result of a city agency colluding with ICE would be able to seek damages, and also would be a way to also seek policy change, right, in order to stop this from happening again. And the second thing that I'll mention is that a couple of months ago, our mayor here in New York City issued an Executive Order 50, which seeks to return ICE and other federal agencies to operate on Rikers. And the city council has filed a lawsuit to prevent that from moving forward. There is currently a temporary restraining order, and there will be an upcoming hearing on a preliminary injunction. So those are two of kind of the big things that are moving at the moment. And I'll stop there for time.
We are going to turn to audience questions in just a moment, but I want to wrap up with maybe something that's a little brighter than some of these other topics. So Cianna, last week when we were talking, we talked a bit about how New York state agencies doing kind of what they do as they do it in their everyday practice can actually have a fairly significant effect on the issuance of visas or getting other relief to people who are otherwise undocumented. Do you want to, I'm not sure if I'm giving you enough direction to flag what I'm asking you, but is that something that you would like to discuss?
I would, with a little more detail. I'm trying to think of what you're referring to. What were we talking about?
So we were talking a bit about how some of the existing state enforcement efforts, including with the State Department of Labor or other, if not law enforcement, then law enforcement-esque agencies can assist people who otherwise might not have any options for status. So we were talking a bit about how things like T visas or relief around labor violations might allow people to get some status.
Exactly. So there is something called the U visa and the T visa, and the U visas for individuals who are victims of a crime. And if they were available and they were available to prosecution or to the law enforcement to serve as a witness to help find the suspect or what have you, law enforcement can sign off and you help them to get a U visa. And for the T visa, it's a trafficking visa. And if an individual was part of a trafficking or has been subject to, for example, if they were the Department of Labor, the New York Department of Labor specifically, if an employer like held someone, victimized an individual in their workplace, I'll just leave it at that, then you could file a complaint with the New York Department of Labor, and that complaint could be used as a basis for a T visa. So there's a lot of different avenues where the state agencies are very helpful. Obviously, we must give the biggest kudos to the special immigrant juvenile status, which allows a state court to find that an individual, unaccompanied minor, or a minor with just one parent who's under the age of 21, to be found to be a ward of the state, for lack of a better phrase. And so they become eligible for some sort of for green card in the long term. So there are really good avenues where the state court can interject and intercede and add to someone's visa application and eligibility. So and here in New York, we have a really good court system. I've had some wonderful judges for SIJS, and it's a beautiful process to see that happen.
Thank you. So I just wanted to wrap up with the slightly lighter note of there are affirmative things that state government in all the branches is able to do to and is already doing to assist people getting status. If I can ask Shella and Pat, can we run a little over to answer some of the audience questions that came in?
Yes, I think at least one of the speakers will need to leave. So for those of you who have to leave at 1, that's okay, please do.
So we have received some really great questions that have come in, and I'm hoping that we can get to a few of them, and then for a couple, we might be able to follow up afterwards. So we received one from Professor Ayers, who asked Cianna, who asked Ms. Freeman-Tolbert, the practice that you described of law enforcement releasing people to ICE before adjudication of their criminal case, has that always been a common practice, or is that now something that you're seeing more frequently under the second Trump administration?
It depends on the crime, honestly. But I can speak specifically, what we're seeing now is an influx, especially for DUIs and things like that. We would always see a final conviction. We would have a conviction before, and it wasn't even to the level where they would send them over to ICE all the time, right? For DUIs. Now, someone gets arrested for a DUI, automatically you're going to be detained and you're going to be moved over to ICE. We're seeing that constantly right now. So it's more than before. It's more than the prior administration, and it's more than the prior Trump administration too, I would say, what I'm seeing right now.
Zach and Yasmine, I know that you kind of see things from a different vantage point at a broader state level and specifically in New York City. Is that something that you would agree with, just in terms of how things are playing out right now? Or are you seeing something different?
No, I wouldn't add anything there.
Yeah, neither would I.
We have one great question that I am hesitant to address because it might send me on a bit of a rant. But we received a question about where the immigration court is for upstate New York. It sounds like if local criminal court jurisdiction is lost for somebody who's detained, there's very little that can be done to get them released before ICE proceedings run their full course. What are the most important initial steps for an immigration practitioner to do when a person is detained by ICE to have some chance for relief? So I will answer the first question because it is a significant barrier for a lot of people. So for all of upstate New York, everything, I think north of Westchester,
Yep.
sometimes including Westchester, is in the jurisdiction of the Buffalo Immigration Court. So from Albany, that is a trek by car, and that is an even longer trek by any sort of public transit, not to mention very expensive. And so that is a huge barrier in and of itself. There is some movement and flexibility with remote proceedings, but I think that remote proceedings also present real due process issues. They wouldn't, for instance, be acceptable in criminal court for various reasons that don't necessarily have the same protections in immigration court. But the even access to virtual hearings, it can be a real challenge for people. I think for the other folks, what are the most important initial steps to do to try to get somebody released from ICE detention?
If someone's been detained and it's due to an arrest, the first thing I do is try to reach out to their public defender, try to get the police report, because it's moving very fast. Because that's what we're going to need in order for us to succeed on a bond hearing. So we know already. We used to be able to negotiate with ICE to see if they would release them, because ICE has the ability to release someone on bond as well. But we know already that that's not an option right now. ICE is not releasing anyone on bond. So in order to get a bond, you have to go in front of an immigration judge. So the first thing you're doing is you're gathering up the police report. You're trying to track your foreign national to see where they're at. Right now, they're going to Montgomery County, I want to say, facility, and then they go up over to Batavia detention facility. So that's the first thing you're trying to do. You're trying to touch base with them. You're trying to figure out if they have a prior removal order, because that makes a big difference. And so you're just trying to get their immigration history, and it can be very difficult.
Yeah, just to really stress that last point, I think one of the most critical things is to know what type of case this is, to the point about whether they have a removal order. And I just dropped, it's old, but it's still relevant, a resource in the chat that was created by the Immigrant Defense Project and Make the Road New York to try to help, because we know that even for attorneys, let alone for family members, it's very difficult often to understand if someone is post-order, right? And if they are post-order, what kind of order they have. And knowing what kind of order they have also impacts what kind of relief and options they might have. So this resource kind of tracks, like, someone's been detained, in order to know what their options are, like if they even will have a right to a bond hearing. This helps you understand, is this person in regular removal proceedings? Do they have an old deportation order that requires filing something with a court? Do they have an expedited removal order that might require expressing a fear if the person has a fear of return? So understanding what type of case and the procedural posture is really critical before being able to advise someone. And often, because we know that doing Freedom of Information Act requests take time, and that can't be done at the drop of the hat, often that requires, really, especially for attorneys, making sure that they're talking to their client, making sure that they're talking to their family members, and just doing some fact finding and investigation to try to put the puzzle pieces together.
I will just also add that also the main thing we're asking now is how long have they been in the US? If they've been in the US under 2 years, we know that expedited removal is on the table. And that means DHS can remove them without placing them in immigration court proceedings. And so that just means everything has to move faster. So
when you say faster, can you give an example of what the time frame is?
I would say if someone got picked up here in the Albany area this afternoon, they would be here at least for one full business day, I would say, before they get moved to a facility. On a good day, our hope is they move them up to Batavia. On a bad day, we've had people get moved outside the state to another facility. And that's how fast they're moving, especially when it's within 2 years. And Department of Homeland Security has the ability to do an expedited removal order without the court. We know that the only way we can really stop it is if we have some kind of credible, reasonable fear claim, and we have to find them to ask them that. So it becomes really fast.
That is super fast, especially given the dearth of immigration attorneys across the state, particularly upstate. Yasmine, are you seeing something similar in New York City? I don't know if that's a question you can actually answer.
Yeah, I think time will tell.
We are 5 minutes over, so I do want to wrap up. We received several questions regarding people's rights and what to do in immigration rights. Yasmine, does IDP have any resources on that?
Yeah, that was the one thing I wanted to say, and I also, in doing that, want to just at least briefly respond to one of the questions that's related. First, for everyone to know, IDP has updated and now many more available in many more languages, Know Your Rights materials. I'm going to drop the link for everyone to have access to, because these are really materials that we really encourage being shared, not just with immigration attorneys, but really in every type of space people are a part of, right? This is about really trying to get as much information to as many communities as possible about their rights with ICE, and in a way that's really accessible, right? That's not hyper legal, and that's really kind of digestible for people. But the other thing that I wanted to just quickly at least name in terms of evolving changes under this administration of ICE enforcement tactics, to Dave's question, is that we know that one of the things that has evolved significantly and that very practically has created new questions for immigration attorneys that are trying to advise their clients is this question around freedom of expression and expressing opinions, about a whole host of political issues, right? And I think it is safe to say that historically, when immigration attorneys do their consultations with people, right, we ask them where they came, when they came, what their status was, who their family members are. We don't usually say, can you tell me all of your political opinions, and can you tell me all of the ways you've expressed your political opinions? There are questions certainly in the process of adjustment of status and naturalization that are kind of, historical questions on those applications that ask those questions. But the way that we have seen people targeted and we have seen people detained and proceedings initiated, sometimes under parts of the law that we have not seen in decades used in any circumstance, is not only has not only put a lot of people at risk and created a lot of fear, but just very practically for attorneys and for students of the law, is really changing the landscape on what immigration advisals look like in ways that are kind of ever changing, right? And we can say today what we understand to be potentially impacting someone, and next week that advice may change. And so I think maybe just one takeaway that I would really like to emphasize for people who are practicing immigration law or working with immigration attorneys or studying immigration law is that it's really, really important to be keeping your ear to the ground and understanding that we have to constantly update our advisals and the information we're sharing with people to be reflective of the reality.
I just want to note that the IDP materials are fantastic. They're available in about 5 million languages, and I use them for my own clients, and I'm endlessly grateful for all of the resources that IDP puts out. They're really great, and if you don't know them, you should. I would love to stay and talk with you both for another few hours, but unfortunately we do have to wrap up. Hope that we have a chance to talk again soon. It's been a real pleasure. So thank you so much for joining this, and have a great rest of your day.